Let's talk about personal jurisdiction in divorce or domestic violence cases, or even custody cases. In order for court to make any decisions about the other spouse has to be meeting certain requirements, or in other words, the court has to have jurisdiction over the person on the other side. So let's say husband and wife live in New York, and then wife decides, it's a hypothetical, to file for restraining order. But in reality, she just wants to move to California. So instead of filing a relocation request to move from New York to California, she says, hey, I'm going to visit my parents. Then she flies to California, files for restraining order, and then the question is, does the court have jurisdiction over her husband, who has never been to California, who is now realizing that something is off, is not flying to California, so he hasn't been served in California? Does the court have jurisdiction? And there are 4 different variations when court could have jurisdiction. Number 1, the spouse on the other side needs to domicile in California, meaning live in California. In our hypothetical, that's not the case. So the question is, if someone lives in California, but they say, hold on, I'm non-immigrant and I have no immigrant status in California, can I still be considered like I'm domiciling? Yes. So anyone who lives 3 months, well, actually, it doesn't matter how long. As long as they're living in California, that's it. The 3 months requirement for living in the county and 6 months in the state, that's just for filing for divorce. So that's different. Second requirement, volunteer, and it's or. So it's not cumulative. So either that or that or that. So or voluntarily appearing in court or in the jurisdiction of California. For example, if that wife said, hey, it's my birthday, come over, and then he comes over to California and she serves him through a process service. So anyone other than her over 18, or she can pick professional process service, serves him the domestic violence restraining order or divorce or both, then the court has jurisdiction over him, personal jurisdiction. So served, or she didn't serve him. So let's say he came to visit her. She gave him the paperwork and said, hey, by the way, here's the restraining order, here's the divorce, here's the paperwork. So he's on notice, but he's not personally served because it's her giving him the paper, not someone over 18. So there is no service. And then he sees, oh, on Monday there is a court hearing, and then he appears and says, oh, everything she says is a lie. Well, he made an appearance. He conceded through his appearance and contesting the domestic violence restraining order. He made so-called general appearance. That means in that moment on, because he didn't speak to a lawyer, to use the keyword to prevent general appearance called special appearance. So he could have appeared and said, hey, I'm specially appearing. I haven't been served. And this case needs to be dismissed because the court doesn't have jurisdiction. Different story. If he appears and doesn't say the keyword special appearance, then by default, it's considered general appearance. Or he didn't appear on Monday at all. He started discovery. So he got the case number, he got the paperwork, he didn't respond, and he started sending her bank subpoenas. Too late, conceded to jurisdiction. So we have domicile in California, a voluntary appearance, which is through service, appeared in court without stating I'm specially appearing, or starting discovery. The 4 is minimum contact. Minimum contact to California would mean that the spouse the spouse who is out of state has California ID, California business. So either owns something in California, real estate, businesses, bank accounts, or doing business in California. That would be enough for minimum contact. There was one case where a spouse lived in California for 6 years with his wife, abandoned her for 25 years and they used to have real estate and then left for 25 years, the court said, yes, enough for minimum contact because they owned real estate and he abandoned the children and wife after. Sending children to California from New York to have education or visitation is not enough to concede to California jurisdiction. I created this book to help you understand the divorce process without getting lost or without getting a heart attack. You can buy it on Amazon in all formats, including audio format. And point where sufficient contact has been established, the case called Hogue, Hogue, where husband sent a mock video of his suicide, to wife living in California, and the court said it's sufficient to establish jurisdiction in California. So now, in our scenario that I mentioned at the beginning, husband didn't go to California. He just stayed in New York. So what would he do? What his attorneys would do? So they would file, for example, a motion to say wife or the child needs to be returned to California because New York is home state of the family, of the child. And then in California, if she attempted to serve him somehow by mail, she sent him, his lawyers would file motion to quash service or motion to dismiss because of lack of jurisdiction. So it's very important to notice that in divorce, even though the court does not have personal jurisdiction over the other spouse. So let's say, and that's my typical case, where a spouse says, my husband lives in Germany and I live in California and he's never going to come. I know that. So, but I want to be single. I want to remarry. What do we do? So in that case, we do file for divorce because she lives in California for 3 months in San Francisco, 6 months in California. And then we serve her husband through Hague Convention. That's international service procedure for countries that are signed up to the Hague. And then once we serve him, 6 months and 1 day after we served him and he did not respond to the proceedings, and even if he responded, the court probably would not have accepted personal jurisdiction because there is nothing out of these 4 things that I just mentioned, but she still is going to be able to get single status. It's called bifurcating marital status. So lack of personal jurisdiction allows to get single status, but does not allow everything else. Division of assets, spousal support, child support, domestic violence. So it's very important to distinguish these intricacies. So I hope that was helpful and I will see you soon. Bye.